nos assistiu depois. A gente começa agora essa nossa nova série, né, que a gente chama de Legal Innovation Talks. Enfim, é uma nova série que a gente está criando aqui em nosso escritório, o Opice Blum Advogados, e a ideia é que a gente faça debates recorrentes acerca de questões inovadoras envolvendo o direito, envolvendo tecnologia, envolvendo a nossa sociedade como um todo. E a ideia é que seja um debate sempre com convidados aí, às vezes até não advogados também, e a ideia é que a gente trate de forma bem leve sobre temas diversos, mas sempre com foco de tecnologia e direito, tá? Esse nosso tema hoje eu vou apresentar daqui a pouco, mas eu queria já deixar aqui essa abertura e essa proposta que a gente trouxe para vocês, e vai ser sempre muito bom tê-los aqui conosco nas nossas futuras oportunidades, tá? Eu estou abrindo em português, mas a nossa conversa aqui vai ser em inglês, porque a Martina ela é nossa convidada, que depois eu se apresentar, e ela não fala português, então eu vou mudar agora para o inglês, tá? Não se assustem, mas fiquem tranquilos que a nossa conversa vai ser super leve e fiquem à vontade para que vocês mandem perguntas aí pelo nosso canal no YouTube. Mandem as dúvidas que vocês tiverem, que vai ser um prazer a gente responder essas perguntas, tanto pela perspectiva da nossa lei brasileira, como também um olhar europeu e quem sabe até lá dos Estados Unidos também, uma vez que a Fernanda e a Martina são super especialistas em privacidade e proteção de dados, tá? Okay, so moving to English now, we're going to start our debate today. We choose a topic to start, and we are going to address data sharing with tracking devices for the monitoring of COVID-19. This is the main topic that we're going to address during our call, but we can go to LGPD, we can go to GDPR, we can move on some other topics related to data protection, cyber law. So feel free to send your questions to our chat. I'll be monitoring our chat, okay? I'll moderate Martina and Fernanda. And I think that at this time, Martina can present herself and then Fernanda, and then we can start the debates. But Martina, before we start talking, I'm only going to present myself. My name is Caio César Carvalho Lima. I'm a lawyer, I'm a professor, I'm partner of Opice Blum Attorneys at Law, and I've been working there for more than 10 years, for something around 10 years. It'll be a pleasure to be the moderator of this debate today. Martina, please go ahead.
So, hello everybody, my name is Martina Anzini and I am a PhD and I work as a legal policy analyst at a think tank based in Germany, whose name is Center for European Policy. So I assess the legitimacy of the initiatives undertaken by the Commission and by any other EU body as to their compliance with EU treaties.
So hi, I'm Fernanda. I am from Opice Blum. I'm a lawyer from Opice Blum, also a professor, and I'm going to talk a little bit on the Brazilian perspective regarding tracing apps. So Martina is going to be the responsible for addressing the EU perspective, and she's going to bring us an overview regarding the European Union. And I'm going to, with Caio, of course, just bring a little bit of our experience here in Brazil, even if it's not even compared to EU, but we're going to try to bring as much as an insight regarding the theme here.
Okay, thank you, Martina. Thank you, Fernanda. I hope we'll have really a good debate here. 1 hour of hot topics we're going to address. And Fernanda, could you please open the debates and by mentioning what we're going to address from the Brazilian perspective? We know there's a brand new decision from our Supreme Court, mainly related to the Brazilian Institute of Geography and Statistics, which is the IBGE or IBGE, Instituto Brasileiro de Geografia e Estatística. And if you can address the decision, it'll be really good for us to start and have our debates. And then I think that Martina can address the same, how those topics are being addressed in Europe, mainly, because we know that also the national authorities are really struggling to come to a conclusion whether you can or not trace mobile apps, or if you can trace, you can collect and use data, if that data needs to be anonymized or something like that. So the debates are really hot on those topics. And I think that it'll be really good for Fernando to start by the Brazilian perspective, and then Martina can give to us some background from Europe.
Of course. I'm just going to I think that, Caio, it's also important for us to define what the tracking devices are consisted in. Even if in Brazil we have this decision, I think that in the European Union and also in a lot of state members, they have a very clear view on what these applications should mean and what they should address. So I'm going to talk about the Brazilian perspective, but I just want Martina, if she can contribute and introduce this topic, for her to give us a brief definition on what are those tracks and what they consisted in, and then we are going to talk about Brazilian perspective. Just
Yes.
to start with this concept.
Good. Okay, I think it's really good to start with the concept because probably someone that is watching may not know what it means exactly. So Martina, please get to us a landscape of what it means, and then we can move to the Brazilian perspective and going deeper to that before it probably will be not good. So thank you, Fernanda. Martina, please.
Sure. So first of all, contact tracing is a process defined by the World Health Organization as a monitoring process that involves the identification and management of probable and confirmed cases of infection. So the purpose is to treat the person which is infected in the earliest possible phase of the illness, and to rapidly identify the so-called secondary cases, so persons who were infected by the first case, so as to interrupt the transmission. So what is the contact tracing already exists in its manual version because, like in every epidemic, the doctor is gonna ask you who you were in contact with in the epidemically relevant period, so as to identify the so-called secondary cases. But of course, digital contact tracing is much more effective because basically manual contact tracing entails requires a lot of time, requires a huge workforce devoted to this. Whereas with digital contact tracing, you can just be more effective. And this is crucial for illnesses which spread as fast as the COVID. So experiences in Asia show that digital contact tracing was key to keep the pandemic under control. I can make reference to China and to Singapore. And the starting, let's say, idea is that this digital contact tracing should have to do with the smartphones, because smartphones are devices which we always constantly carry with us, that we do not lend, on which we have an exclusive control. And so the idea of an app naturally came out as something which could provide help in this case to make contact tracing more digital. So this is just to frame the discussion. Then maybe Fernanda can introduce the discussion in Brazil, and then I can tell you what the debate is about now in the European Union and what the European Union has already done on this topic.
Okay. So in regard to first of all, it's very interesting that you brought up the Asian perspective here, Martina. We know how important the tracking device were in Asia, but we also know that there are a lot of breaches regarding to privacy. So this is a very important difference, and this is what I think European Union is trying to limit. And because we know that the data protection is a fundamental right, and we know about the how European Union is protected and is concerned in regards to this subject. So it's very, very interesting in order to just make it to put into perspective both sides of the table. And in regard
Fernanda,
to, yeah.
Before you start, also I have
Yes.
to mention that Martina said something really important, because sometimes we fear what you're doing on the digital perspective with mobile devices, but we do not fear the same thing being doing with papers, with documents. So this is something really important, that we need to understand why we sometimes fear some things with the digital age, with digital tracing, but if we're doing the same thing offline, for example, then we do not fear that. So I understand the reasons and why people try to fear more the digital perspectives, because Martina mentioned that you carry your mobile phone everywhere you go. Anytime, if you're going to sleep or when you wake up, you are with a mobile phone. So there's a reason for that, but I think that we fear without a great perspective of what are being done. So Fernanda, please go in deep the Brazilian case, and then we can address the European perspective with Martina and try to compare things being doing offline and online, and why probably regulators are so afraid of the digital perspective.
Yeah, it's great what you brought up, Caio, and also it's important to remember that data protection law in Brazil here, it applies not only to digital digital data, digital personal data, but also to the ones that are not. So this is very important to have into perspective that when we are talking about this kind of data, personal data regulation, we are talking about digital and analogic. So this is very important. In regard to the Brazilian, different from the European Union, here we do not have a minimum requirements or framework like we have in the EU. In EU, they have directives, they have the European Data Protection Board that already pronounced about the theme, and they have minimum standards they have to ensure when developing apps or when addressing the topic regarding tracing apps and the COVID. Here in Brazil,
okay, I think that we had a problem with her.
Of the. Are you listening?
No, sorry. You
Okay.
stopped, but you can go ahead. Sorry.
Okay. Here in Brazil, I'm going to give some examples on the initiatives that we have here. But as we do not have a minimum standards, we had a very important Supreme Court decision that ruled out against the exchange of data. There was a provisional measure, the provisional measure 954 from 2020. And basically, I'm not going to enter into details because we are going to address a lot of topics here, but basically the decision, the provisional measure was obliging fixed and mobile telephone companies to make available to IBGE the list of names, telephone and numbers, okay, addressed of their consumers, individual or legal entities for the production of official statistic, okay? So, and the Supreme Court decision ruled out through a direct action of unconstitutionality, rule out the declaration of unconstitutionality of the measure, okay? This was based on three main reasons. First of all, the Supreme Court, the Brazilian Supreme Court stated that the provisional measure did not explicitly stated the purpose of using the statistical research. So there was not a specific purpose on this provisional measure, okay, in the exchanging of this data. Second, it does not demonstrate how the data will be used. So there was not a clear purpose. There is not which goals and shows that it was not in accordance to our legislation, because we have to have a specific purpose in order to share this kind of data. And it does not provide technical or administrative mechanisms capable of protecting personal data from unauthorized access, accidental leakage, or misuse. And the fourth point was that it does not guarantee proportionality of the data used. So summing up, this was the main reasons why the Supreme Court ruled out this provisional measure. So this was the first decision, and very important to Brazil, because if you think about the status of protection rights as constitutional rights, you start seeing that we are constructing this kind of understanding by ruling in against this provisional measure. The Supreme Court, the Brazilian Supreme Court, clearly stated its understanding on how the matter should be dealt and understood here in Brazil. So it was a very important precedent for us to have in mind and to balance the discussion here.
Thank you, Fernanda. It's really important, that summary of the decision of the Brazilian Supreme Court. And you addressed the 4 points that probably in Europe, they already mentioned and studied those 4 points. And it's interesting because although Brazilian law, LGPD, is not yet in effect, Supreme Court took a lot of definitions and principles on our law, yeah, and bring those principles to their decision. So it's really important because it come to a debate in Brazil because of that situation, and it's a way for us to improve and to start a debate on the Brazilian LGPD, and we started that debate on the Supreme Court. So definitely, yeah, it's really important for us to have a lot of definitions on the Brazilian law, since it's a brand new law and it's not yet in effect. This is why we are always trying to get from Europe what they think about those topics, because there in Europe, they have a culture on data protection, and they have more material, more doctrines, and more case law on those situations. This is why Martina is going now to talk us about how European national authorities are deciding on those situations, if you could use that data, and if you can use, what you need to do to avoid violating laws.
Sure. First of all, I would like to start by saying that maybe the European debate is a bit more advanced when it comes to the kind of contact tracing app, which is which is better for member states to use. And also, I should highlight that the debate has been pretty much at the national level. So it has never been, there has never been a real pan-European project. The Commission and the European Data Protection Board have issued guidance concerning how, at the national level, such apps are supposed to be framed to be in compliance with EU law, and notably with data protection and privacy law. In terms of like public debates, and in terms of the initiatives which are now like going on at the national level in Europe, it is important to highlight that the debate is converging towards the so-called proximity recording app. So the mobile tracking seems to be off the table, definitely. And proximity and the choice is supposed to fall on apps which only record epidemiologically relevant contacts. That is to say, contacts which are relevant because they took place long enough and with a level of proximity which is sufficient to trigger a high risk of infection. So we do not, like the app in which are being considered right now, should record only contact events which are epidemiologically relevant. So how is this app supposed to work according to the model which is gaining terrain right now? So the app works based on the Bluetooth technology, and it produces temporary identifiers, and at the same time it collects temporary identifiers of nearby devices. Such detections are called handshakes, and they can be stored centrally on a server or in a decentralized fashion on each app, so on each device of belonging to an app user. Then the third part of this, the third element of this proximity recording app is the warning mechanism, of course. So in case of a centralized recording, basically the COVID case contact history is uploaded onto a central database. And the apps continuously check if the temporary identifiers they produced match with the identifiers stored on the central server. If this match is found, the warning message appears on the device of the app user. In case of decentralized recording instead, if I find to be a COVID case, I have to send the alert message to all those who were in an epidemiologically relevant contact with me. So it is more problematic by a practical point of view because I have to decide that I want to share. It's not like I'm sharing this information because nobody will know that it was me, but it's something which is up to me somehow. So by a public health perspective, it is a bit more problematic. These temporary identifiers produced by the apps, according to the Commission, should not qualify as personal data because they would not make it possible to trace back the device and therefore the data subject. As a consequence, the General Data Protection Regulation, which only regulates personal data processing, should not apply. The e-privacy directive instead certainly applies. The e-privacy directive is a legislation which protects privacy and the confidentiality of communications in the electronic communication sector across the EU. It is a harmonizing legislation. It particularizes and complements data protection in the telecom sector in respect to the GDPR. So, like the debates, there's been a lot of debate in the European Union as to whether member states can impose basically the use of this app. I don't think that this is the case because of the e-privacy directive. So notably, like in order for the app to achieve its purpose, the app needs to access information which is stored on the smartphone. And pursuant to the e-privacy directive, access to this information by the app is only possible if it is intrinsically necessary for the app to work, and according to the Commission, this is not the case, or with the consent of the app user. Therefore, the consent of the app user seems to be a requirement for those apps to comply with EU law. Also, the e-privacy directive provides like public interest grounds which allow member states to restrict some guarantees provided by the e-privacy directive. This is also the case for this specific guarantee, which I have already mentioned. But the e-privacy directive mentions upon the public interest grounds, which enable member states to do so, for instance, fight against crime, national security, but certainly not public health. Therefore, member states do not seem able to rely on this public interest clause to restrict the guarantees which the e-privacy directive offers to information technology services users. Concerning the guidance provided by the EU, we have a communication issued by the Commission on this topic and a guideline by the European Data Protection Board. I will mention the main takes from those texts. So wherever personal data processing takes place, both the Commission and the European Data Protection Board mentioned that national health authorities must be the controllers of those processing operations. The individuals need to be empowered, so need to remain in control of their data, even in the context of the use of contact tracing apps. So app use must be voluntary, and the individuals must be able to exercise the rights they enjoy under the General Data Protection Regulation in case personal data processing takes place. And the app has to be deactivated when the pandemic gets under control. Also, like the app needs to comply with the principle of data minimization and has to minimize data storage. So this proximity data, which are collected, should be deleted as soon as possible. Last thing is the involvement of data protection authorities. So data protection authorities need to have a close look at those apps, and a data protection impact assessment prior to the deployment of such apps is essential because of the impact which such apps could produce on the rights of individuals. So I think that, so this is my illustration of the situation in the European Union. There's like no app has been launched in the European Union by any big member states. So we are still waiting for a real model to assess and to study. So far, it's only information which we can obtain from the guidance offered by the EU authorities and the EU institutions.
Thank you, Martina, for that picture. It was really good. You mentioned the GDPR, you mentioned e-privacy directive, you mentioned EDPB, and also national authorities debates. And Fernanda, I would like you to address from the same perspective, but trying to analyze, for example, if in Brazil, the government or any state would like to have that COVID tracing apps, do you think that the consent would be needed in Brazil? And also another debate that Martina mentioned is there any way to impose the usage of the app, or we may rely on the perspective of the data subject? Okay, I need to go there and put my data. And also something really important that Martina mentioned is that since Europe is far ahead comparing to Brazil when we talk about data protection, there was a decision that she mentioned stated that we need to think for how long the data is going to be retained. And she said, okay, you need to delete it as soon as the pandemic gets to the end. And also another thing that I would like you to address, Fernanda, from the Brazilian perspective is, how do you think it would be important for companies or for those apps to do a DPIA, a data protection impact assessment, like Martina mentioned, mainly considering that we do not have yet the Brazilian LGPD on place. And this is a good debate here because some authorities are trying to apply Brazilian law, even if it's not yet in effect. So there's a lot of discussion here on that, Martina. And also, Fernanda, last but not least, a lot of questions is, Martina mentioned the e-privacy directive. And how do you think that this conflict of laws is going to be in Brazil? Because we have our internet law in Brazil, which is the Marco Civil na Internet, and also we will have Brazilian GDPR, which is LGPD. How do you think that those laws are going to be in place at the same time, considering all those discussions and those debates and focusing on those COVID tracing apps?
Okay, so there are a lot of, I tried to put everything down here, Caio, but please feel free to complement me.
Okay, I have my notes.
But first of all, regarding consent, I'm going to mention Brazil does not have right now, and it's a very interesting perspective. And me and Martina were discussing this previously. Brazil started ruling out regarding this theme on the Supreme Court. Okay, the European Union started ruling through directives and guidelines, and of course the legislation. If we think on the Brazilian reality, we started backwards, because we don't even have the Brazilian National Authority in regard to data protection. The legislation is still discussing and regarding if it's going to be on its full efficacy on August, or if it's going to be postponed. So there are a lot of discussions, and still the Brazilian Supreme Court has a decision. Okay, so we are, as you can imagine, a very different country regarding this legislation, but it is a very important decision. Okay, so I can start it by this decision and by this precautionary measure that was imposed. First of all, if we think about consent, this measure did not have the consent on the users, but it mentions the possibility of doing a DPIA. Okay, so if you read the precautionary measures, I'm sorry, there was a DPIA stated as is important, and the IBGE should do a DPIA regarding its content, regarding the data it's collected. So this is the first thing that I wanted to put on the table. If you think on the timing, there was also an article on this measure that stated that all the data should be deleted soon after the end of the epidemic. But if you think on the end of the epidemic, it was very broad. There was not a definitive date. So it was also a point that was taken under discussion. So this was the things that, and the measure already recognized the importance of the DPIA. So this is the first thing that I want to highlight here. So I think that the DPIA is going to be essential for all these tracking devices. If we look to the Brazilian perspective now, we have two main streams, I think. You have measures that, for example, the government of São Paulo, through the Technology Research Institute, signed an agreement cooperation with a technology company using artificial intelligence to support the government in its analysis regarding COVID apps. The purpose of this agreement was to look onto population displacement and to see how the population behaves and how their movement. There was not the population consent here in this agreement. Also, the city of Rio de Janeiro also signed a similar agreement, also sharing anonymized data in the form of a heat map. So both initiatives are allegedly used anonymized data, and they were focused on geographic and localization of the individuals to see how people are moving on during the epidemic. So if you think about, this is not about the spread itself, but it's to evaluate if people are staying in homes, okay? So they do not asking for population consent, okay? You also have initiatives regarding some technology companies with states in Brazil. So these technology companies, they're providing data from the apps, because they have these apps that they develop, and they are providing those apps as platforms. These devices are tracking people despite of their consent. So they're basically integrating an application program interface that has in a lot of application and a lot of well-known devices. So there is not an opt-in and an opt-out. So there's this kind of initiatives here in Brazil, and you have also other initiatives such as Brasil Sem Corona, and which is a partnership, and you have to download the app in order to and provide information, and you authorize to share this information with the states and some municipalities. You have also the Onde Tem Coronavírus initiative with the governments of Bahia and Paraíba, okay, to monitor COVID. So people are providing voluntary information. So you have the two scenarios here in Brazil. You have some states that are collecting data, okay, to not just to track not just to see the contamination, but also to see if people are staying home and to do all kinds of monitoring. But you have this all other kinds of initiatives that people are voluntarily downloading and uploading these apps, such as those ones that I mentioned to you. There's also another one that I want to mention to you, that is the COVID app. It's a very great app. In fact, Caio, this app was developed in Pernambuco, and it's a very in a partnership with the State Health Secretariat, and all the data from Ministry of Health and State Health Secretariats of those states that are part of the initiative are used and are connected with those data voluntarily provided by the users of this app, and they are crossing the databases in order to provide this kind of statistics regarding the contamination. So you can see both scenarios here in Brazil. And so you have not a centralized vision here, but you can mention states and municipalities taking their own initiatives and their own programs in order to monitor and to combat the spread of coronavirus.
Thank you, Fernanda. It's really interesting when we see that we have different initiatives from different states and cities. And when we look that all of the privacy perspective needs to be regulated by the federal state, which means that those states locally or those cities locally, they could not address the regulation by themselves when we're talking about privacy or personal data protection. So it's a great discussion we have in Brazil, and definitely it'll take a long time for us to come to a conclusion on that, and definitely for that debate to have started on the Supreme Court will really help us to have a great debate and a high standard debate on that. And I would like to move to probably our last topic, since we already did that introduction. I would like you to address one question from the chat from YouTube, which is from Pedro Sanchez. He asked about the labor perspective, the internal perspective of the companies. And he asked that, what do you guys think about the use of wearables on employment relationship in a way to trace if someone is in a place with a lot of people, or if someone may have contact with someone with COVID. So he's trying to get the internal perspective, and he would like to know if companies in Brazil and in Europe are using those wearables, and if they're using, if they can do so from the legal perspective. I would like to start with Martina and then move to Fernanda for her to give her inputs on those topics. Martina, please.
I have already highlighted that any initiative, like any model of app, contact tracing app, which is in compliance with EU data protection and privacy law, relies very much on consent. Also, let's say for political reasons, because like people in the European Union, and especially in the country, I mean in Germany, are very concerned about data protection, and they have a very conservative approach. So if we talk about an app which has to rely on the consent of users, we also have to consider what consent means. So according to the European Data Protection Board, the consent needs to be free and freely given. In an employment relationship, it is unlikely that the employee is in the position to choose between using the app or not. So the consent won't be considered genuine from the perspective of the GDPR, but even from the perspective of the e-privacy directive, because they use the same notion of consent. So I would exclude in the European Union that you could like even ask actually your employees to use this contact tracing app.
Okay, thank you. And Martina, imagine the situation that, for example, I have a company and then I will test all my employees before they enter into my company. So I'll test them and each day. So Monday I test, Sunday, it doesn't matter. If they're going to enter the company, then I'm going to test them. I'm going to do this with a doctor. They will know exactly what type of data is going to be collected and for what purpose the data is going to be collected and for how long the data will be stored. Do you think that this is okay to take that situation?
This is a tricky situation because it's about health data. So I think that it needs to be assisted by some kind of special guarantees because like health data have a special regulation under the GDPR. So I'm really not sure that this would be totally okay. But if I understand your example, it wouldn't be like would it be something voluntary, something that I have to do?
You need to do, because and why I'm asking you that, because here in Brazil, we're starting to see some companies that are getting back to work or planning to get back to work, probably on June, and then they are trying to have a massive test of their employees before they enter into the company. And so there's a huge debate in Brazil whether companies can do that. If they can do that, they need to have a doctor doing so, and if they can store the data. And if there's an employee with COVID, then what they will do, they will forbid that he or her join the company, and what they're going to do with that data. So there's a debate in Brazil on that situation.
Now that it is also a debate which is going on here, but mainly like the public debate in this pandemic has been how to find tests. So because like when the pandemic spread, for instance, in Italy or throughout the European Union, like there was a lot of difficulties in gaining access to tests. So the accent of the debate has been more on this. Like I don't know what exactly how the GDPR would be applied in this case, to be honest. And also, like, this is at the EU law, but there could be restrictions which could operate even at the national law by the point of view, of labor law. So we should also look at that perspective.
Okay, thank you. And Fernanda, what do you have to add from the Brazilian perspective on that question from Pedro? Thank you.
First of all, Pedro, thank you for your questions. I think that you have here, besides, you have the collision of two fundamental rights. So if you talk about fundamental rights, you have the right of privacy of the employee on one hand, and you have on the other hand, the right for the protection of life of individuals. So when you have the collision of two fundamental rights, what the constitutional law usually says that you can waive one right, and you have to choose one right, but you have to analyze, you have to it's basically a test that you have to assess in order to see which right you should prevent or should be the one that should be put in perspective. I think that in this case, we are talking regarding to protection of life. So suppress the right of privacy, I think we could just justify, even if when we talk about consent, and I agree to Martina, of course, we're talking about consent, and we know that consent in an employment relationship is very, very tricky for you to get, and it's a very complicated matter. But when you're talking about the right of protection of life, you can justify this kind of suppression, and you can almost equalize this kind of tests, and this is my perspective, okay, to the protection of employee. So at the end, you are doing such measure to protect your employee. as long as you have the guarantees and you can ensure that all this data is going to follow the rules and it's going to be minimized and is going to look to the purpose, to what it was collected, and you have everything written on policies and internal rules and you guarantee it. I think of course this is going to it's a very, very tricky situation and a very important discussion, but this is my perspective. But I think that you can justify even if it arises to Supreme Court.
Thank you, Fernanda. And we are we're coming to the end of our debate. And I have one last question from Ana Maria. And she asked us as a final question, whether it is possible to reconcile monitoring for COVID-19 control with respect for privacy. So it's a closing question. So I think you can have your final words and also address that question from Ana Maria. Since you have only 8 minutes, probably it will be our last question from the public. So Martina, can you start that, please?
Sure. Like, in my opinion, we have to reconcile those two terms, because it would be a bit ironic to have all those technical means and then to react to epidemics as if it was the plague in like the ancient days, like to close ourselves in our apartments and houses and not to go out. So it would be indeed desirable to make them work together. And I think that this is definitely possible, although it poses serious challenges, as we have also confirmed today.
Fernanda?
I agree with Martina. I think that we have to reconcile. I think it's the principle that is fundamental. We are talking about privacy, we're talking about fundamental rights, we're talking about our data. At the end, we have to have here, and this is what I was discussing with Martina in the morning, that we have to have here the sum, of course, considering the perspectives, but here we're trying to protect the individual. Here now we have access to privacy never seen before. Even when the state after the Second World War gave the privacy and input privacy as a fundamental right because of the abuses of the Second World War. If we see the context now, we are much more looking and we are having and access to each other's privacy, and everything that you do is being monitored. So not only in the tracing apps, but in all aspects of our life, we have to have this kind of balance. And this is why such legislation is so important right now. Such legislation and such rules are the future. And more and more, we are going to have to deal with this kind of issue, not only the pandemic, not only with the tracing apps, but in our daily life. And I think that we have to be conscious about what we have to do about it. And I think we have and I think that as a lawyer that deals with it, and I think that it has to be something that we have to pass to the population. Everyone should be aware of what we are talking in regards to privacy and data protection law.
Okay, thank you very much, Fernanda. And thank you, Martina. Do you want to add something? Do you have one final words or something like that? Fernanda, Martina?
No, I think that I closed my argument.
Martina?
Me too, because whatever I would like to add would be too long.
Yes, true.
I'll totally run out of time. So
yes.
I think like this.
Okay, So thank you very much, Martina, and thank you very much, Fernanda. It was really a good debate. It's almost 1 hour, and really time passed really fast. So thank you very much. The debate was really on a high level. Definitely, we'll need to get back to that topic soon, because things are changing really fast here in Brazil and in Europe. So we can have some updates on the next weeks, and we can have another debate like that. So thank you, Martina. Thank you, Fernanda. I'm going to move to Portuguese to have one closing word, ok? Então, pessoal, obrigado aí por vocês terem assistido essa nossa conversa. Foi realmente uma conversa muito boa. E eu deixo aqui o meu convite a vocês da nossa próxima Legal Innovation Talks, que vai ser nesta quinta-feira, dia 28 de maio, às 18 horas. E a gente vai ter a participação da Daniele Serafino e da Mônica Magalhães, que ela é futurista, especialista em estratégias disruptivas aí pela Harvard Business School. E a gente também vai transmitir esse debate aqui pelo nosso canal no YouTube. Tá? Então, eu espero vocês agora no dia 28 de maio, quinta-feira, às 18 horas, tá bom? Um abraço a todos e até a próxima.